Joseph Marino. This is part two of our discussion for the summer 2011 bar exam. And we were discussing just briefly the essays and reminding you that in these essay questions that you're going to state the nature of the problem, the issue, the controlling rule, general and exception, go into the discussion, in this case here or since, and as I was just saying in the end of part one, you now need to explain the facts under the rule to answer the question. As you explain those facts, the bar examiners want you to justify your conclusion. And the way you do that is explain all other relevant transactions. The more material facts you discuss, the higher your grade's going to be. So remember, during the exam, discuss the facts, explain the facts. The bar examiners refer to this as rah-rahs, rule application. And so explain as many of those facts as you can, because as you explain it, you're justifying your conclusion. And of course, you end with the therefore, which is the answer to your question. Now, don't worry about formats and don't start to certainly chase or change your writing style. But because there is no technical way you have to do it. And at this point, it's showing them you understand the problem and you can discuss a resolution, but it's premised upon some proposition or rule of law. Now, on the actual exam day, you know that the 5 essays will come at you in different subject groups. And so that one of the areas that you see on this exam are your transactional style essays, the transactional ones, the essays that have some significant contracts in it or other types of transactions. And these essays will cross over to other subject matter, will not necessarily just stay within it. But that with this, right, I believe that you should probably take a good look at your formation issues, including even in sales, looking at just basically how they form, looking at a battle of the forms or an offer and an acceptance, and looking at whether or not they've actually formed a contract, versus the performance issues of the contract. As I mentioned, that business orgs is important, and they can easily put in the contracts essay or it's a separate essay. Business orgs does have certain transactional aspects to it, and you never know where they're going to put any one subject. But I would look a little bit here at your partnerships is what I would do. And I would just looking at partnerships, looking at the liabilities of the parties. So your basic general partnerships to understand those relationships of an existing partnership, a withdrawal of a partner, a new partner, transactions under the original partnership and under the new partnership. And these are very traditional. Liability, liable, on the existing debts for your capital contributions when you join, but not, but you're not personally liable, versus when you are a partner. But also look at your limited partnerships as well, recognizing that, again, they are not personally liable, as all they say within those little safe harbors. But I wouldn't overdo it. But just again, I think that you may see some basic partnership, or they could fool us and give us a professional corporation, a professional limited liability partnership, where the partners are shielded from the basic commercial debts, but not from their own negligence. But you should have a nice question that's going to have some contracts and somewhere a business org, and I'm thinking you may see that partnership. Now, the bar examiners do ask an occurrence essay, and that's fundamentally a tort-based style essay. Here, go over your negligence. I think you should see a good negligence question on the exam. But they also love to put procedure in this question, and so just to remind you of a few procedural considerations as well. But first, just remember that in negligence, that can include medical malpractice. So don't negate medical malpractice. Remember, New York does have a wrongful birth cause of action, where the doctor misdiagnoses a birth defect and the baby's born with this defect, and the doctor is responsible for the extraordinary costs in raising the baby due to their neglect. That even if there's a government program or insurance, the doctor is still responsible because they never cover all of the extraordinary expenses, although it may adjust some of the verdict or costs associated with it. Also interesting enough that, and it is that in negligence, as a procedural issue, to remember that we are a comparative negligence jurisdiction, but it must be pled by the defendant. If the defendant doesn't plead comparative negligence, where the defendant is asking the court to reduce the verdict by the plaintiff's negligence, if in fact the defendant doesn't plead that affirmatively, there will be no adjustment, that despite whatever negligence is attributed to the plaintiff, the verdict will not be adjusted. And this is true, for instance, with Article 16, where a defendant says, I should get Article 16 protection, and therefore the plaintiff should not be able to collect any more than my apportioned share of wrong for non-economic loss, unless I'm more than 50%, in other words, 51% responsible. Both of these have to be affirmatively pled separately, because one doesn't plead the other, and without pleading, the defendant doesn't get that protection. Right? That also, we've seen some interesting things dealing with copyright infringements, where a publisher in New York has material that's online and somebody in California steals that. Now, as a procedural consideration, well, as a tort, we know that the tort has occurred in California. That's where they stole it. So we have a procedural problem, which is how do we get jurisdiction in New York? We need long-arm jurisdiction. This is a tort out of state. Now, we've constantly had a problem in New York because that the 302A3 requires there to be then harm in the state. That conduct out of state, that tort, has to harm somebody in the state. And the traditional analysis here has been a very difficult one, because that they really didn't sell the book in California. It's not like they didn't sell the book in New York. And so in order to get it in the statute, the court finally looked at this and said, this is not these traditional torts. The internet's everywhere. And so that they, by law, have been holding that the harm does happen in New York, regardless of where the copyright infringement occurs. Now, this only gets you that first part of the test. You still have to meet those criteria, the qualifications. In other words, there has to be some overall contact or revenue derived from the state, or they should have to foresee, which they very likely will foresee by stealing this, consequences in the state, but it would have to be coupled with their interstate or international commerce, which may be the difficult one, and also remembering that it still has to be a minimum contact and not offend due process. But the main problem the courts had is we can't even get past the threshold, but now the court says that copyright infringement anywhere, when you have your publisher in New York, does cause harm. So at that point, we now can go into those qualifications in our minimum due process discussions. That also, interestingly, is that in the areas of commencement, where you do commencement by filing and 120 days to serve, if you succeed, the defendant then is considered, the statute of limitations is considered interposed on the date of file. And you take longer than 120, the plaintiff could ask for an extension of time on good cause or interest of justice. I believe extensions of time or correcting mistakes can in fact become part of the procedural consideration. As far as extending time in these discretionary extensions, that they're based on either good cause, which is good cause for the delay, or interest of justice, which is explain your delay. If you have no explanation, we're not concerned with anything you have to tell us, but if you can explain your delay, then tell us in the interest of justice why we should extend the time. both require, to some degree, an explanation for the delay that has to satisfy the court. Now, in the CPLR section 2001, and this allows the court to correct errors. In fact, it allows the court to correct errors in the commencement process. Let us say the plaintiff doesn't file, serves the defendant makes an objection under the commencement. First, the defendant must raise the objection. If they don't raise an objection, they waive any objections to the commencement process, but that they must raise their objection. Now, under 2001, the court could say, okay, file now, because the concept is we can fix mistakes of method. But 2001 is not meant to correct a mistake of what was filed. It's not meant to correct your substantive issues, just the mistakes of method. So now, in my example, when they file, the statute will not have run. But remember, failure to file the summons complaint within the statute of limitations is not correctable by 2001. Had the statute expired, the court couldn't have ordered filing to correct the method because they're now affecting a substantive right as to what was filed. So while 2001 allows the court to correct things, not if it violates a substantial right of the parties or due process, which means that the failure to file the summons and complaint within the statute cannot be corrected by 2001. It would offend Section 201. It would in effect be an extension of the statute of limitations. Now, again, remember that in these areas that there's a number of other areas that could go or related, but I think this may be something you'll see. And I don't want you to forget farm nonconvenience, that there have been some interesting cases, and you know the court can decline jurisdiction and, in fact, can interpose conditions in a farm nonconvenience. Right? That what we're going to do now is pause, and you're going to need to go to part 3. All right? You'll have to go to part 3 now.